Hello. Today is the first webinar of our new series, Houston, We Have a Solution, organized by Houston Place for Arbitration. We have our first and very brave guest, Enrique Jaramillo, who is the partner at FBFK. He has recently joined the firm. So Enrique is originally from Ecuador, and today we will speak about the differences between civil law and common law and his experience in studying and as a lawyer specialized in both legal systems. So Enrique, tell us, how did you end up in Houston?
But first of all, Daria, thank you very much for inviting me to be your first guest. It's really an honor, and I'm very happy to be here. How I ended up in Houston, it was, a very happy coincidence, I would say. I was living in Brussels at the time, and I always wanted to come to law school in the US, but of course, you know how expensive that can be.
That's true.
Yeah. So I was in Brussels, I was working there, but with a lot of free times in my hands. I prepared for the LSAT, which is the exam you have to take for the JD, and I did fairly well. And I just, click a box in the LSAT website saying, do you want that I wanted to basically, send my results to all the schools in the US.
Mhm.
And I did, and UH sent me an offer letter offering me a partial scholarship. So then I basically, I had different options at the time. I did some research about Houston because I confess I didn't know much about the city. And I discovered it's an amazing city with a great economy, great community, amazing, business community as well. And here I am, thanks to the scholarship of UH. And then, of course, because of the great economy we have here, I ended up staying.
Thank you to the University of Houston. So you said you were studying in Brussels, and we all know that you were studying in Ecuador as well. What's the difference between the legal studies in civil law countries versus the US legal studies as a representative of the common law legal system?
Of course, when I first, before I came to law school here, I thought it was going to be easy for me because I already, had gone through law school in Ecuador and done a master's in Europe. And I was so wrong. I think having studied at the civil law, countries made it probably a little bit more difficult. Because I guess because civil law has this approach to try to regulate as much as possible via statutes, and they try to go into detail, into things. The form or the way they teach you the laws, but basically learning these laws by memory, right? So I remember one of my hardest tests when I was in law school in Ecuador was I had to give an answer about, it was a criminal law test, criminal procedure law test. And I have to give an answer to a question citing the article where the answer to that question was. And that was all memory. And it was a code with like 1,000 articles.
So here you don't need to learn the course decisions. Can you use the course decisions when you are studying or writing your exams?
Yeah, here is way more engaged, I think, because what they do here, at least in UH, is you are on call almost every day. So you have to read, I would say, probably 100 pages per day of cases. And then you're going to talk about it in class, basically. So you need to be, every single day, you need to be prepared for that. And then when the exam day comes, you have to basically solve a problem based on the law that you know. But actually, I think all of my tests in UH were with open book. So it was just a matter of understanding the law, understanding the concepts, and knowing how to apply the law to a certain, as to some facts, instead of just memorizing some articles in the law. So that was a big change. And I think, making you be on call every day forces you to be more engaged and more up to date with the things you're learning every day. So that's the major difference, I would say.
Do you have an impression that the common law professors are more engaging, giving you more opportunity to speak up yourself than the civil law professors?
Absolutely, absolutely. So I guess the method here, and I don't want to generalize, of course, but at UH, it was a very Socratic method of the teachers, more than teaching you something per se, it was more asking you questions and making you think and coming to a conclusion, from the things that you read the day before. Whereas in my studies in civil law countries, it was more, kind of a magister conference where somebody came and spoke about a topic, and then at the end of the semester you had to give a test. You have to give the test on that. But here was way more a conversation, I would say, than just a conference.
So, as I said, we will speak today about the differences of common law and civil law, and I've prepared a little list of questions for Enrique, apart from his background. So what are the most striking differences for you, Enrique, between common law and civil law? And if you can give examples from your professional life, from your cases, or anything you've read, actually.
Yeah, there are so many differences. I will have to say the main difference is going to be, of course, the use of case law, right? That can be at the beginning can be a little bit daunting because there are so many more things that you have to know, to be able to give proper advice. But eventually becomes a very nice tool, because what happens when you have a statute and you only have a statute like in civil law countries, and you want to apply that statute to a certain, transaction or dispute, there are certain nuances in the disputes and transactions that are not going to be governed by the statute. And here, under a common law system, you have definitely had a case, like yours or similar to yours, that you're going to be able to just apply that, analysis from the courts to your particular decision. So that's one difference. The other difference is that civil law can be more formalistic. And I guess that comes from the whole Napoleonic and the Roman influence of the system, in terms of, for example, having the power to bind a company for certain, contracts, just some formalities in terms of having to notarize things, having access to the public authorities. That can be more formalistic than in common law. And again, I don't want to generalize. I don't know how, for example, things are in England. But at least the way it works in Texas and New York, I think it's way more flexible than civil law countries.
Do you think that AI is more practical for common law than for civil law in looking for this case law and researching the cases which may be helpful?
AI is amazing. It is amazing. I started using AI for work maybe some months ago. And of course, you have to review the results. But it's an amazing start to whatever research project you have. So now we're at the point where we have, it's just a ChatGPT. So it's not ChatGPT, but it's the same technology used only for legal purposes, based only on, legal databases. And it's just wonderful. It makes your life so much easier because sometimes you have one particular question that it will be easy to answer, but it's going to take some research. And now you just, make the question, you get the answer in 1 minute. So yes.
As a Ecuadorian and US lawyer, imagine you have to choose a law applicable on merits and on procedure, but they should be different. Which law will you choose for what?
That's really tough. You know what? If you'll have to be different, I would prefer to use, a common law system for both of them. But if I had to, I'll probably go to the merits. I will pick up a common law jurisdiction because it's going to have, case law, which is going to be way more robust than you will find in civil law country. And for procedure, again, there are differences between, the procedure here in the US at the federal level, at least, and also in the state level, compared to the procedure in other countries. But it's nothing really major. Maybe the biggest difference is going to be jurisdiction, so you'll have to be mindful of that. But mainly I think that's what I would do.
But what about this difference of administrative law? So some people say that the administrative law doesn't exist in the US. I think that maybe it does exist, but that's my opinion. So for instance, if you have a contract with a state or with a state entity, and you want to have the law applicable to this contract, so will you choose the civil law or common law, and why?
For administrative contracts, I will definitely pick common law as well.
Common law?
Yes.
Why?
Yes, you know why? I have little experience with administrative contracts here in Texas, to be honest. But I have quite some experience in Ecuador from those contracts. And in both jurisdictions, the state or the administration is going to have certain prerogatives that private parties do not have. But I think those are stronger under civil law jurisdictions for sure. And that has changed somewhat in the recent years, especially because of all the investment arbitrations that have come from the rescission of some certain contract with the states in Latin America in particular. But there's still strong protection towards administration. Here, I have come across a couple of examples where, of course, you have some protections for the administration, but there's nothing too scary really. It's just
the administration is not as strong
I think
in Latin America, or it's not that strong here.
I wouldn't say it's not a strong administration. I would say the protections to the administration are less strong here than
I
they
see.
are in their civil law code. But again, that's just my opinion, right? I'm based on Ecuador and Texas.
Okay, thank you so much. The next question is on this principle of steady decisis, although you already talked about it. Do you think that this principle create more predictability compared to the codification of roles in civil law or not?
Well, sorry, can you repeat the question?
So does the principle of steady decisis, so the use of previous cases, create more predictability compared to codifications in civil law or not?
No, absolutely. No, it's more prevalent in common law. There are some cases. Again, I'm going to talk about Ecuadorian law, and again, I haven't practiced law in Ecuador for a long time. But there is some use of precedent, right? When you have 3 different rulings from the Supreme Court, for example, that is now called the National Court, you could create precedent if the court decides to make those 3 rulings a precedent, and that's mandatory. But in other cases, it's not really used a lot in the real daily practice. Not even as far as I know as a guidance, for other decisions. So really little role of the court's decisions in Ecuador. It's just basically the you and what the statute says, right? And the ability of the lawyers to make arguments.
But how do the courts in Ecuador interpret the statutes? They should be bound by some rules, right?
That's a very good question. So doctrine takes a really important place in civil law. So you have different sources of law. That's what they're called. And you have the statutes, of course, adopted law, and then you have, tradition, then you have also doctrine. And at the end, you have jurisprudence in certain little cases. But in practice, it's very important. That's something I didn't see, for example, here when I went to law school. In Ecuador, you will study these treatises from, authors from even 50 years ago, real big, long, books about these topics. And judges do use those opinions of authors to interpret what the law means.
Do they quote them?
Yes, absolutely. So you will find constitutional courts, I'm talking about Ecuador, rulings from the Constitutional Court or the National Court citing authors. And of course, they have to be very renowned, respected authors. It's not just any.
That's something we can all aspire to, be good, renowned authors, right? So in terms of contract interpretation, which approach do you find more balanced? The textual approach of common law or more contextual purpose approach of civil law?
That's a great question. To me, I think it's a matter of opinion, But to me, I don't want to seem too sided towards the common law system, but I think it's better to just stick to what the contract says, And then each party has to they have the responsibility to negotiate the terms of the contract. And then once you have a written, signed, concluded contract, you need to be bound by the text, by what the law says. And I think in certain cases, again, as you said, civil law goes more to the purpose of the contract and have some other restrictions even that there are exceptions really. But in some cases, the law may, be more important and have precedence over what the parties agree to a contract.
Does your civil law background help you in your day-to-day practice here in the US?
Absolutely.
And I know there are a lot of restrictions. You cannot talk about everything, but can you bring the examples when it really helps and the examples when it didn't help, but kind of what they call also the faux amis, when something is really similar, but actually it's completely different?
Yeah. No, well, I give an example of that. I use it every single day. I use it every single day because, I would say all of my clients, they come from civil law countries, all of them in Latin America and Spain. And, being able to translate not just the language, but also the interpretation under the legal systems are very important. At one point, I think I told you about this, I spent probably 2 hours talking to a lawyer from a civil law country, trying to explain to him the concept of apparent authority, and then you can bind a company to arbitration in certain states, most states in the US, just by having apparent authority. And he just couldn't get it. So I spent an hour just trying to make him understand that it's just like that. And that happens to me every single day because I deal with lawyers in other countries, in Mexico, Ecuador, Colombia, Peru. So it's very, very useful to me. And that's one thing. And one of the concepts that are very similar, that seem similar, but are very different from in the US from other countries, is the concept of jurisdiction. And that, to me, you would not believe how how hard time I had trying to comprehend the concept of jurisdiction here in the US, because in Ecuador you have procedural code, civil procedure code, and then you have jurisdiction over a party, at least back then, if you have a domicile there, that's it. So there's no other way to get jurisdiction over a party. But here you have that under the concept of general jurisdiction, but you also have this, to me at that moment, weird or rare concept of a specific jurisdiction, minimum context and the
international shoe.
International shoe, exactly.
Everybody.
That everybody studies in law school here. It's a civil law 101, CIPRO 101. So that to me was like, it was really breaking my mind back then. But it's also a very interesting tool because it attracts many disputes to state and federal courts. So that's something that can be very different, and seems familiar, seems the same, but it's completely different.
So do you think that the US courts are even better in marketing by attracting as many cases to them as possible?
I think that the courts try to strike a balance, and they are aware that they want to bring, of course, some disputes, but they also know that the more disputes they bring, the harder it is for them to manage so many cases, right? So I think that even though you have the law to here decide the cases here, the courts try to, whenever possible, just derive them to other jurisdictions. And you have the concept of forum no convenience, for example, for that, right? That is very well used, and it's hard to argue sometimes in court. So it's a balance, I would say. It's balance.
So apart from jurisdiction and apparent authority, what other concepts you find very difficult to explain to the civil lawyers?
Those are definitely the hardest. Other things that I prefer to keep confidential.
That's a pity.
I'll talk to you after the conversation.
Yes, it will stay forever on YouTube,
exactly,
right?
Exactly.
So next question. So do you think that the clash between civil law and common law is more evident in international arbitration or in domestic courts?
Absolutely. I think it's more evident, definitely international arbitration, because it happens, I think it's the rule, basically, right? At least for me, to have team from different legal families. In domestic courts, it's always going to be domestic lawyers, and every now and then you're going to have to apply maybe a different law to the merits, but usually it's just domestic attorneys making their cases. In international arbitration is, again, I work a lot with Latin American parties, and there's a bunch of businesses between Latin America and the US. So the usual case is a Latin American party against the US party, for example, and then you have that kind of you have to reconcile so many concepts between the lawyer, because in arbitration most things are by consent, even the procedure, the hearings, the process, everything. So you need to come to certain decisions sometimes, and that can be a clash. But you know what? It's not only in international arbitration. Sometimes when you are in even domestic arbitration, sorry, I was referring to, there might be a clash between people used to do international arbitration in the US and people in the US who don't do arbitration often. And when they go to arbitration, these litigators, they bring these litigation concepts into arbitration, and it's a completely different animal in many different ways. So it's similar, but you have, for example, the issue of discovery. So when you have somebody who is not used to international arbitration or to arbitration in general, you're probably going to find somebody or a lawyer who's going to expect to have a broad discovery in the case, which is not always the case, or even the purpose, if you ask me, of international arbitration, right? So there might be clashes between even people here in the US sometimes.
Can you describe your ideal international arbitration tribunal? Let's say you have two parties, one US party, one civil law country party, let's say somebody from Latin America. If you have to choose a sole arbitrator, who will you choose?
Who's my client?
Not the name.
Who's my client? It depends a lot.
Okay, your client is from Latin America.
Probably the civil. It's so many factors you have to consider, right?
For instance,
say that if my client is from Latin America, the applicable law is going to be let's say Ecuadorian law, and then we have a project in say in the US, and the other party is a US based party. I'll probably try to pick somebody from a civil law country for sure.
Okay, if you have 3 members tribunal, will you choose 2 US lawyers, one versus one civil, or 2 civil lawyers versus one common?
I will pick one civil law arbitrator who is very good convincing the other arbitrator to appoint somebody who might be more acquainted with our side of
Okay.
the story.
Are you more afraid of civil law arbitrators or common law arbitrators?
No, I'm not afraid of any arbitrator.
That's great.
I think the idea is to, if you select the arbitrator
Mhm.
properly, you're gonna have a great case because they're gonna be able to manage the case. So besides, being acquainted with the law traditions and the law of the
Mhm.
case, having somebody with experience, it's gonna make a big difference, regardless of whether they are, they come from a common law system or a civil law system. Because at the end, a good arbitrator will understand the concepts, and you, of course, will have experts explain the concepts to them anyway.
Mhm.
So it's gonna work fine. Just as long as you have a good, experienced arbitrator,
Mhm.
I think that's the most important thing for sure.
So the question, a little bit opposite question to one I asked before. So how will you explain some civil law concepts to the US lawyers? Before we talked about explaining concepts of common law to civil law lawyers. Now, when you have to do inversely, how will you do that?
You know what? That's actually easier for some reason.
That's easier.
Yes, absolutely. And I think it's because, again, civil law has so many formalities. Then when you explain to a civil law lawyer that you don't have to follow so many formalities here, they're like, no, that's impossible. Because it's ingrained in our minds, from where we are in law school, you have to follow certain things, right?
Mhm.
And if you do not, you have, basically null contracts, you waive things. But here, because the law here is not flexible, but it's less formal than in civil law countries. I think it's easier for a common law lawyer to understand that things might be different, in other places. Again, that's just my experience so far. Maybe I will find tomorrow somebody who is very hard to explain
Did you
something.
have any difficulties or never? Never any difficulties with explaining the US law to civil lawyers?
No, I mean, sometimes difficulties, not really. Sometimes actually every single week I have to explain something new to somebody, but they understand fairly easily, One silly example, for example. So one time, I think we sent an engagement letter to a Latin American client, and they were expecting the letter, and I signed the letter, representing the firm, and the client was expecting to send a letter from the legal representative of the firm, because in this case was Ecuador. In Ecuador, you have one person appointed, and you have to register his appointment in a public office, and then that person is the only person who can represent the company for everything. So they were expecting the letter to be signed by somebody of that capacity here in the US. And I explained to them, we don't need that in the US. And they were like, are you sure? And that was it. But again, the minor things, really minor things.
Minor things. That's great. Do you think that the tension between these two systems undermines the consistency of arbitral awards? Do you think, for instance, that the same, let's take the administrative contracts, right? The administrative contracts is really an animal which exists more in civil law countries, with the clause exorbitant de droit commun, the exorbitant clauses which are in the contracts. So do you think that the same case, for instance, let's take investment case where there's this contract between a state and a private entity, and do you think that the same case will be decided differently by the arbitral tribunal composed of civil law lawyers and by the common law lawyers?
Absolutely.
You think it will be different?
Absolutely. But you know what? I think that's not just between common and civil law lawyers. I think it can happen in different, courts in different states here in the US, right? And it can even happen with people from the same legal family. But absolutely, as I explained before, I mean, there are some concepts that are very different, right? And a person with a different background will definitely decide something, different from the other legal family. But again, if you have a good arbitrator, they will give you, I think, a fair ruling. But definitely, I don't think consistency, of course, is something we should, try to obtain for arbitration. But I think it's in general, because of how the system is structured, it's really hard to obtain. Here in the US, you have some consistency because at the end, you have higher courts and you have the US Federal Court, the US Supreme Court. And at the end, you might end up with some consistent rulings and some consistent rules. We don't have that in arbitration. I don't know if that will be achieved in the investment side with the new investment court.
What's your opinion about the investment court?
I think
not really about the difference, but
so to me,
interesting question.
To me, I don't like it.
You don't like it?
No, I think it defeats the purpose of arbitration, really. The idea was to get away from bureaucracy and from courts, and I think it's another court. It's not arbitration anymore to me. It's a different court.
In civil law countries, there's this opinion that arbitration is too expensive. It's for sophisticated parties. In the US, I'm not sure that arbitration is more expensive than litigation. What do you think?
Yeah, people say that. I don't think it's more expensive. I think it can be way cheaper, actually. Again, depends on how you manage the process, right? But just by the fact that you can limit discovery, which is a huge expense in litigation, that can make your case way, less expensive than going to court. I was involved in a case a few years ago where we had to review, I think it was 3 million documents in discovery.
And that's something we don't have in civil law countries. Right?
Exactly. That is also a big difference in the procedure. Discovery is a major difference. And that's, that changes the whole tone of the dispute, because just by having to reveal to the other party, and that's also something that I have been a hard time explaining to my clients, that you have to produce documents that are relevant to the case. That makes a big difference at the end.
And it's very difficult for civil law people, trained lawyers, to understand why you have to produce something which is not good for you, right?
Exactly.
That's the case.
Exactly. But you know what? Without, of course, I'm not talking for any client, but I think in general or in theory, even though it is expensive and even though it's a lengthy process, I think the fact that both parties have to reveal all the documents they have, it's basically, it might get you a more fair outcome of the case, I would say.
Before I continue, I see that we have quite a lot of attendees unexpectedly, so maybe we will ask questions.
Sure.
Maybe some of our attendees want to ask questions, so please raise your hand if you want to ask question. Let's see.
They're shy.
They're shy. Nobody wants to ask questions? Okay, I will continue then. So let's talk more about discovery. Do you think that discovery should be really limited in the United States, or it is something which is proper to the US legal system and it should be left as it is?
That's a very good question. I think there's always room for improvement. Absolutely. And it can get ridiculous for sure. I mean, I think again, depends on the case, right? But it can, 3 million documents, more than 3 million documents, this is a lot of documents. And you spend so much money just reviewing the documents, and just consider how expensive legal services are in the US also compared to, other jurisdictions. So it's definitely something that can be improved. But the idea, I think, is really good. I think, again, it depends on who you represent. If you represent the defendant, maybe it's not such a good idea. But in theory, like in the general theory, I think it's good. Can it be improved? I think so, yeah, for sure.
Do you think that discovery is something which will be dealt with by AI in the near future?
Absolutely. That will be a great, space for AI, and that will save so much money. And we are so close to, I think we are so close to that, close to that. Now you can, we use tools, every day where you upload a document and you ask a question about the document, they give you the answer. So I don't see why we cannot use that for discovery. I have not heard of many people doing that yet, but it's definitely something that where AI is going to have a big room.
So the other question, do you think that the global legal harmonization is possible?
No. I don't think it's well, everything is possible, I should say. But I think there are so many differences. They are so big sometimes that there's going to be some resistance from the different jurisdictions to to go through a single legal theory, let's say, a legal theory. And I think that's fine. I don't think we need to harmonize everything. I think we just need to find a way to make everything work. And in that sense, I think we have so many tools already. Of course, a lot of room for improvement. But again, we have arbitration is a great way, I think, to harmonize many things: business disputes, transactions. The New York Convention is amazing. The convention to also enforce mediation, settlement agreements are just terrific. I think it's a great tool. And that it doesn't matter which legal parties come from. You get to enforce your agreement anywhere. I think that's just great.
Now let's talk about the US law versus the law of countries which don't have the federative system, so which consists just of one global law, right? Like I'm not specialist in Ecuador law, but I understand that Ecuadorian law, there's one law which
Yes.
exists, not like here, Texas law, New York law are different. Do you think that it's difficult in this international legal context? It's difficult to manage all these applicable laws, like the federal law and then the law of each state?
I think at the beginning it's definitely, daunting, but eventually it becomes part of your regular day, I think. But it definitely adds a couple of degrees of complexity to the cases, right? And I can give you many examples, but just there's so many things you need to be aware of. Maybe that's why lawyers are more expensive here than in other countries. But definitely it's complicated. And for, let's say, for international arbitration cases, and you want to enforce an award, you need to be, aware of, the state arbitration law. You need to know how that is going to interplay with the Federal Arbitration Act as well. You need to know, again, depending on where you are going to enforce the award, different decisions from different courts, the issue of jurisdiction again, so many different things. I don't want to speak for other countries, but I think, except for maybe Mexico and Argentina, most countries in Latin America are not federal countries. They're all just, presidential unitary jurisdictions.
Countries, right?
And so it's way easier because you have just one body of law, and then you don't have case law. So that makes it, that can make it easier, I think, but also more complicated because it gives you more room it gives the judge more room to make decisions that might be, not in line with what you were expecting, basically.
Another question. I know that nobody probably has an answer to that, but it's just a question which really fascinates me. Latin America, all the countries are situated next to the US, which is a little bit like big brother for them, but still they do have this civil law applicable in all these countries, right? To my knowledge, I don't know any other country in Americas apart from Canada, right, which has the common law.
Maybe some of the little countries in the
probably maybe Guyana,
maybe
Guyana. But why do you think, notwithstanding this huge influence of the US, these countries kept their civil law traditions?
I think it all goes back to the era when the Europeans began to discover this continent, and it's just we got our tradition from in the case of the Spanish-speaking countries from the Spanish and the Portuguese, and they all use civil law, and they got their influence from the Roman Empire, or the Roman Republic, and from the Napoleonic Code, and they just they gave us that, and for people in the U.S. and in Canada, they got the influence of the British, and they got their common law. So it's just for me, it's just a matter of that. And again, it's not even. I don't think this is something that people in civil law countries want to even adopt. I think they're very happy with what they have. Maybe some things have been discussed. For example, the use of a jury for some cases. I know at some point in Ecuador we had juries. Didn't work so well for criminal cases. That was a long time ago, before my time even. I think they're happy with what they have, and they're very proud also of the system. They should, because it's an amazing civil law. It's a terrific system with so many, again, influenced from great times of the Roman Empire and the French Empire. So
speaking about jury, did you participate in civil law cases, not civil law, but in civil cases with jury here in the US?
No, and they are very rare.
They're very rare.
First of all, you almost never go to trial because you end up settling in discovery, because by the time you have produced all the documents, you kind of have an idea of what's going to happen at trial. So it's better to just, find a good settlement is better than any good trial.
So what they show on TV, it doesn't exist?
No, it does. It absolutely does. I guess it's more prevalent in criminal cases, right? But for civil cases, it's very rare. I have met people with, 40, 30 years of experience litigating in courts, and they have had maybe like 5, 10 jury trials. So super rare. So no.
Okay.
I look forward to it.
So we're still waiting for questions. Oh, we do have questions. Amazing. Okay, so a question from Enrique, who is also the dual qualified lawyer. Dear Daria and Enrique, I enjoy listening to your conversation about the differences between civil and common law systems. Thank you very much, Enrique. We're so happy you're here listening to us. However, do you not find that the results, the decisions by judges and arbitrators in the end are not so far apart in both systems? Both systems look for reasonable and fair decisions. What are your thoughts?
Again, what I said at the beginning, I think if you find a good arbitrator, you're gonna have a good decision. Whether you're gonna like it or not, that's different. But the decision is going to be, well reasoned, and it's gonna be a good decision. Have I found, rogue judges and arbitrators? I have, of course. But the good thing about, I guess, arbitration is that you get to pick who's gonna be your decision maker. But for sure, they're gonna be good decisions. Again, if you have, you come from a different background, maybe the reasoning behind your decision is going to be different. But the use of experts, for example, in arbitration makes a big difference.
But don't you think that this concept of equity is more prominent in common law than in civil law? Because as far as I remember, at least from the French Civil Procedure Court, for the arbitrators with the procedural law, French procedural law, they cannot decide the exaco and bono, which is by equity, right? Unless there's a special clause in the contract. Do you think that the common law allows this equity decision to be taken more easily?
I think so, and I think the reason why is because the courts abuse it so much. So again, you go back to case laws as a source of law, and you have so much support to use equity for a decision, both for arbitrators and for judges. To my recollection, there might be there is something similar, of course, under civil law, but again, it's probably going to be you're going to find more information in the doctrine, right? So the judges have the discretion to use that, but I didn't see it much, to be honest, as you say, when I was litigating there.
Thank you. And we have another question by an anonymous attendee. The question is, what are the most relevant elements that each legal system, common and civil, can contribute to each other? That's an excellent question,
That is an
actually.
excellent
Thank you so much.
So I'm a big fan of again case law. So I think something civil law can definitely benefit from. If you don't want to make at the beginning at least, precedent mandatory, you can at least use it as a guidance for for future decisions. I think that will be a huge step, to improve the consistency of the decisions by the courts in civil law countries. Discovery, it's very controversial. I think
That's right.
some discovery is good. The broad discovery you have in the US, again, room for improvement. But some discoveries should be important because at the end, I think if you don't have discovery, you might win or lose a case by the facts that were not disclosed, right? And it should be the opposite. A case should be decided by the facts that are disclosed. So something like that could be definitely used for civil law countries. As for what the common law systems could benefit from the civil law systems, I think, again, the issue, some formality might also be important in terms of having more certainty of what's going to happen. Let's go again to the concept of apparent authority. That is very vague, right? What is apparent? Who has authority to bind somebody to arbitration? I have found, if you use your common sense, maybe sometimes ridiculous outcomes of people bounding big corporations to arbitration just because of the impression of the other party. So I guess more formality there might be a good, addition to the system. But again, this is just my opinion. So of course, somebody can, think otherwise.
Thank you, Enrique. And from my perspective of French law, actually some of the fields of law in civil law countries, they do take this same system as the common law. For instance, the precedents, the French arbitration law is based on precedents on the court's decisions, and the same with the administrative law, which is really interesting, but it is the fact. We don't have other questions for now, so we will go to the pleasant part of our discussion.
Everything was pleasant. At least for me.
So, Enrique, what are your favorite places in Houston? What's your favorite restaurant?
A client recommended me to go to, I've been in Houston for 10 years, and a client recommended me this year to go to a place called Mastro's. And
oh, yes.
Oh my, they have an amazing steak there. It's really good. The wine, everything was amazing. The experience, there was live music. The steak was, excellent. Good wine as well. So that's definitely a place to go.
And Houston has several locations of Masters.
They do?
Yes, they do. They have Masters in the Woodlands. They have Masters in downtown.
I went to the one in the close to Uptown Park. I think.
Great.
Yeah.
So at least 2 locations already.
Yeah. Well, we have so
Mhm.
many different things all
Mhm.
across the city. We're living in such an amazing city, really, that it's really, easy to live here for sure.
So where would you bring your Ecuadorian client?
Depends on the client.
Sophisticated
you-
Ecuadorian client.
Everybody that I know, all of my clients, I think they will be thrilled to just go and shoot a big gun. So probably to a range.
To the range. Yes, I see. Where will you bring your client from New York?
Oh,
Who's
from New York?
opposed to shooting?
That's a good question. I will also bring them to shoot. No, I'm just kidding.
No. They are
No,
opposed to shooting.
they enjoy, you know what? I met somebody from New York and they are so used to having
Mhm.
fancy food. And what they want is just a good food truck sometimes.
Mhm.
Believe it or not. So that's a nice place.
Mhm.
No.
Your Mexican client.
My Mexican client, shooting as well, probably. There's so
For
many
food,
things to do.
yeah.
Yeah, for food, Masters is a great place. Blue Door is an amazing place. I will definitely have them try Texas barbecue.
Mhm.
So many people from out of town don't know about Texas barbecue, and to me it was a revelation when I
Mhm.
first came
What's
here.
the best place for Texas barbecue?
I'm a very simple person. I don't want to promote any
Okay.
any
No,
chain, but
no money paid for any of
but
us.
I don't go to any of the fancy
Mhm.
ones.
Yeah.
There's one that just got a Michelin star, right? I think it's called, I forget the name.
Barbecue place with a Michelin star.
Yes.
I think that's something you
Yes.
can see only in Houston.
I definitely need to get myself there, but it's a big line, I think. So,
Mhm.
yeah, I'll definitely need to go there.
Oh, we have another question. Perfect. Question from, I'm sorry if I mispronounce the name, David Ortiz?
Ortiz, yes.
Yes, Enrique is better in pronunciation. In international commercial arbitrations, where Latin American and US parties often face each other, the tension between common law and civil law is reflected in very different expectations regarding discovery, precedents, and even the role of the tribunal. From your experience, what profile do you consider most suitable for an arbitrator in these cases? A jurist with hybrid training in both systems, or a collegial tribunal that combines arbitrators from different legal traditions? What advantages and risks do you see in each alternative? Excellent questions, right?
Excellent questions, absolutely. So I think every case is different. So first of all, whether you want to have a tribunal or an arbitrator is going to depend a lot on the amount of the in dispute, basically.
Mhm.
So usually, single arbitrators are usually appointed for smaller cases. If you ask me, I don't want to sound too cynic, but sometimes I think just having one person might be better, because what happens when you have a tribunal at the end is each party selects, and this might be a little bit, again, cynic from my part. Each party selects an arbitrator, right?
Mhm.
And they all select somebody with the background they like. And then what's going to happen in practice is the politics between the tribunal are going to really impact the decision of the president of the tribunal. So whether you get a decision of another, it's going to depend on which arbitrator convinced the president of their
Mhm.
side of the story, basically. And I think you can just save all that money and all that politics within the tribunal if you have one good arbitrator that is aware that is trained in both systems. And again, I cannot stress this enough. Selecting an arbitrator is really important, regardless of whether they come from either families of legal tradition. Just having a good arbitrator making a good decision is going to bring a good outcome to your case. So for me, just one will be my selection.
What do you think about Americanization of international arbitration?
I think again, it's like, to me, it's like the investment court, right? It fits the purpose of the idea. Again, we can all benefit. I think some discovery is good. I think it's good. But bringing all that concept from local courts here to arbitration, it doesn't make. Again, it's complicated because you're gonna have resistance from people from out of the US, and they are right to oppose that for many reasons. But some discoveries, I think, will be a good idea. And I'm talking about discovery because I think when people talk about the Americanization of arbitration, is mainly because of discovery and the expectations as a bit set up the parties, about that. I think if you have somebody training both systems, they can conciliate, both sides and come to a sensitive, mindful solution.
What will be your advice for hearings for a civil law trained arbitrator if he has US parties in front of him in a case?
To get a very good advice from a common law lawyer. He's going to have to rely on the parties, of course, and the experts, but really, I think it might be difficult, and it works either way. If you have, parties from civil law countries and a law from a civil law country, and you have a common law lawyer, it's going to be complicated. And I just had a case like that, actually. Small matter coming from Mexico, and both parties were Mexican, but for some reason, Houston, well, Houston was the place of arbitration, and we selected a Houstonian as an arbitrator, and he had some difficulties, and so both parties were, I would say, were not really super happy with the outcome.
Because that was this exact clash between a
then you have the
common
clash.
law
Exactly.
arbitrator and parties who are from civil law.
Exactly, and this arbitrator was not really well advised, on where the parties were coming from. So I think there was some confusion between the parties on the one side and the arbitrator on the other side. So that can happen. And again, I cannot stress enough how important it is to select your arbitrator, because at the end, it was these parties who selected the arbitrator.
Yeah.
Right. So,
and thankfully in Houston we have so many civil lawyers,
of course, the community
systems trained lawyers.
The international community in Houston is huge. We have so many lawyers from so many countries. As you know, I'm an advocate for the foreign trained lawyer community here in Houston. We have so many members, and great members, that have achieved so many things in Houston. So big international community. I think Houston is the most diverse city in the U.S.
I think so as well.
New York.
Even Russians came here, right?
Everybody's here. Vietnamese, Portuguese, Spanish, Latin Americans, everybody.
So if you want to find your arbitrator, Houston is a perfect place for you.
Absolutely.
Well, I don't see, do you have any additional questions? Well, we had a lot, so maybe we should just round up here.
Yeah, let's wrap it up. Thank you so much again, Daria, for having me. I'm so honored to be your first guest.
Thank you, Enrique. You're so brave, and the discussion was really great. And Enrique did a lot of studies, right, in civil law countries, common law countries, and that may be also called the representative of Houston, where all the cultures, Latin American cultures, come here and mix, and that's why we are such a great community. Thank you so much, everybody who listened to us today, everybody who asked questions. Thank you for being brave. And so next webinar will be with an expert, Miguel Nacle. So this webinar will be on special YouTube page of Houston Place of Arbitration. And we hope to see you soon in real life or on camera. Thank you.